As to the state's motion to restrict the audio feed of the 4 witnesses, all of whom were minors at the time, 2 have since turned 18 years of age, I'm going to deny that motion with one exception. So essentially, their testimony will be allowed by audio. As to all 4, I'm going to allow them to, after they receive the oath, to state and spell their names, but off of the audio feed. So that will not go beyond this courtroom. Much as we dealt with jurors who were discussing private matters during jury selection. They may be referred to by first names by other witnesses. That's fine. So essentially, my order as far as audio is the same as previously ordered, with one exception, that being their names will be given and spelled in the courtroom, publicly, on the record, but without the audio feed going out. As to video, I am going to, even though 2 are technically 18, given their young age, I'm going to continue to suppress the video for those minors as well, all of whom object. At least that's my understanding. Is that correct?
That's correct, Your Honor.
All right. All 4 of those witnesses do object to video, and thus I know technically that 2 are now adults, and Ms. Walker is, I'm sure, very correct that people will be able to figure out who these people are. But in order to give them, this is more to get testifying as witnesses in what is a very high-profile trial. And given their young age, I am going to grant it as far as these 4 witnesses, but no others. So no video at all, audio as previously ordered, with the one modification that their names will be not given out over the audio feed. Now, having said that, media is present. They can report out the full name. I cannot impose a prior restraint on that. And so it is going to be said in a public courtroom. I would note that allowing the audio stream, despite their discomfort, when we compare to what we put, for example, a young criminal sexual conduct victim who has to testify about deeply traumatic and terrifying sexual abuse sitting in front of their abuser, with the public present in a larger courtroom, I think we do unfortunately have to ask a lot of our witnesses, especially ones who are minors, who are victims, and who are victims of terrible trauma. These, on the other hand, are witnesses. They are not victims per se. I'm sure it had an effect on them, but they are not victims per se. They are bystanders testifying about what they saw happening to Mr. Floyd. So with that, any questions about the court's restrictions?